Our next speaker is John Speer from Bass, Berry & Sims in Memphis, Tennessee. John is a member of the firm's litigation and dispute resolution practice, where he represents clients in complex litigation and commercial disputes with an emphasis on representing financial institutions. Recently, John obtained a trial court dismissal affirmed on appeal of a multi-million-dollar damage claim against a bank for alleged breach of fiduciary duty in selling unsuitable financial products to a commercial customer. Sounds familiar, John? As well as dismissal of class action claims against a bank for allegedly conspiring to violate federal and state price-fixing statutes and other laws based on service fees charged. Here to discuss data breach and cyber liability, please welcome John Speer.
Thank you very much. In a recent report by FTI Consulting, along with corporate board member, the most often cited legal concern to 55% of general counsel and 48% of board members was data security. Only 32% of general counsel felt very confident in their company's ability to respond appropriately and quickly to a data breach. What is the basis of that concern? We can start with the GLB, which imposed an affirmative and continuing obligation to respect the privacy of customers and to protect the security and confidentiality of non-public personal information, followed by Dodd-Frank in 2010, which required regulators of financial institutions to adopt rules to prevent, respond, and to approach the safety of personal information and identity theft. Response to that by financial regulators was swift, beginning in 2000. The safeguard rule, which is Rule SP, the SEC, but all other regulators have adopted virtually the same rule, regulates the disclosure of non-public personal information of a consumer to non-affiliated parties, requires notices, disclosures of policies as well as practices of financial institutions with regard to sharing that information to non-affiliated parties. It also provides for the opt-out by customers of disclosing of that information, and also regulates and discusses in some detail how that information can be shared with affiliates of financial institutions. The personal identifiable information, or non-public personal information, consists of two parts. There's personally identifiable financial information, which is information that a financial institution would receive from a customer or from some other source, used in connection with the delivery of a product or service, sale of a service, primarily for personal, family, or home use, or, in addition, to any information received in connection with a transaction with that customer. The second part of that definition is a little broader, and it is more pertinent now given the data mining efforts that are going on, and that is a list of a compilation of information of customers that would identify that customer that was obtained from personal information, and if that information is disclosed in connection with a providing of information to a data mining facility, disclosure of that must be made to your customers. The disposal rule followed in 2005, and that, of course, dealt with exactly what it says, disposal of information that is obtained from a consumer report or related to the information contained in a consumer report. The rule also required financial institutions to ensure the security and confidentiality of records and information and to protect against threats to security. When I hear terms like ensuring, in that context, it does give me a little bit of concern, and I'm sure it does the board members as well as the general counsel who responded to the corporate board members survey. In response to these rules, new enactments of legislation, both at the state and federal level, regulators have been more active. They've adopted a lot of rules, a lot of enforcement actions have been taken, and FINRA has been more active recently in that regard, as well as other SROs with regard to their members. These rules are pretty much track the disposal rule, the safeguard rule, and in addition to that, what we have seen is a lot of industry organizations providing guidance providing best practices, providing information of how you should protect information, how you should deal with these rules. And I will tell you that you see more often now plaintiffs' lawyers using those guidelines, those best practices to support claims against financial institutions based on breach of contract and based on common law claims such as negligence, breach of fiduciary duty, etc. If that isn't enough, effective compliance-wise, in November of this year, the red flag rules were adopted by the SEC and the CFTC. They've been in effect for 3 or 4 years with banks and other financially regulated financial institutions that are regulated. I think now with this purpose of this rule that we see to detect, again, prevent, and mitigate identity theft in connection with the opening of certain accounts or the use of certain accounts, we will see more active regulatory enforcement by other regulators and certainly by the SEC, given the actions that they've taken with regard to the disposal rule and the safeguard rule. The application of this is broad. It covers creditors. It includes those registered or required to be registered with the SEC or the CFTC, investment advisors registered under the Investment Advisor Act or the Investment Company Act, investment companies, hedge fund advisors, private funds are also subject to the rule, broker-dealers who offer margin accounts, short-selling services, possibly municipal securities dealers, a wide range of application with regard to this rule. And different from the disposal rule and the safeguard rule, registered is not the only criteria. It is registered or should be registered or required to be registered. What are the covered accounts? How does that definition apply here? Because the purpose of this is to prevent imposter access to accounts or opening of accounts by imposters. The accounts offered or the accounts covered are those that involve the primary use of an account for personal, family, or home use, which involve multiple payments or multiple transactions. But in addition to the definition, that definition, which pretty regularly tracks in the guidance is what was done in the safeguard rule and in the disposal rule, it also includes any account where its opening or use creates a reasonably foreseeable risk to a customer or to the safety and soundness of a financial institution from identity theft. It could apply to any account, and I think substance. If your financial institution uses accounts in any material way and has accounts, this rule will apply to you. The definition of red flag and the other definitions are laid out, but let me mention, a red flag is a pattern, practice, activity indicating possible identity theft in the use of an account or an attempt to open an account. This rule takes us beyond where we have been because financial institutions are now the monitors, similar to what we've seen with the Patriot Act, money laundering statutes. You're going to have to develop policies, practices to deal with the requirements of this regulation. How do you comply? This regulation lays out a whole series of compliance obligations along with 8 sections of guidance and guidelines, which have already been supplemented, I might add, by other regulators. The program must be adopted, board-level responsibility for that. Identifying red flags, detection of the red flags, prevention of identity theft, mitigation from hacking or improper use or opening of accounts is required, updating and evaluating the program on an ongoing basis, as well as oversight. In designing the required program, this is what the SEC and other regulators have said the purpose is. Control foreseeable risks to customers or to the safety and soundness of the financial institution from identity theft. Very subjective, very demanding, very broad. Let's talk about how you are to respond to the requirements of this regulation based on the guidelines that the regulators have provided. Risk factors that you must consider laid out in the regulation, methods used to open and access your accounts, past experience that you may have with identity theft, new products or accounts that might require a different view from the existing accounts that you have, or when you change accounts, you have to consider the factors that would allow misuse of that account by an imposter or the opening of that account by an imposter as well. There are sources to consider that are required. You must consider guidance from the regulators. I don't think that's any surprise, but as well, industry guidances, information that's out there, methods of identity theft and changes to them, reports and information, and basically information that may signal attempted identity theft or reflects activity usually associated with identity theft should be considered. You're required to consider all of these as you formulate the red flags for your particular institution that will prevent misuse of existing accounts or bar the opening of accounts by an imposter, and for the purpose of preventing identity theft of your customers. The categories, again, suspicious documents, unusual use and suspicious activity. You have to look at that from your experience in your institution. Suspicious documents, documents that would indicate they've been altered. I would also mention inconsistent documents. If you have a series of accounts with a customer that reflects one source of one type of information, date of birth, address, email address, and an application is made to open another account in the name of that customer, but that information doesn't sync with what you already have, that would be a category that would cause you to flag that situation as a red flag in your program. Notices from customers, law enforcement, and third parties. Detection is a key part of this regulation. Of course, the implementation of the policies and the procedures to be used goes without saying, but the use of your customer identification program is referenced in the regulation. You can use that, but it has to be supplemented and augmented by the red flags that you have identified for your organization, and other parts of your red flag rule obligations should be incorporated in your existing customer identification program. The guidance requires authentication of customers, monitoring of transactions, verification of the validity of changes in passwords, and they also mention changes of address is something that should be considered in determining whether or not there is an attempt to access improperly an existing account or to open a new account. Prevention and mitigation. Staff, technology, process, oversight, all of which are important. It cuts across the entire organization. As someone has said earlier, we moved far beyond the IT department responsibility. Monitoring activity for evidence of attempts. Of course, the regs also mention the refusal to open an account would be expected. Closing accounts would be expected to prevent identity theft, and that may be difficult to implement. That has to be a top-to-bottom part of your organization. Checking accounts, broker accounts, any type of account that is applied for that would indicate from your red flags that you've identified may be an attempt at identity theft should not be open. Of course, one of the most significant issues that's come up recently, and there was some reporting yesterday, prevention is probably impossible. We can minimize the risk of identity theft, but the real focus in the future, I believe, is going to be on mitigating, responding, and time is of the essence. This response outline would apply to any type of breach or attempt to access information. Certainly applies in the red flag regulation. Most importantly, secure the balance of your information based upon what has happened in this instance. Be sure that you're reacting appropriately and quickly to that. Investigate the source of the breach. Reporting is important to compliance officers, to law enforcement, and of course you have obligations to notice to customers as well. Determination of the scope of the information affected. Important to know which individuals are involved, where they live. Each state, there are 47 states that have privacy statutes. Notice to them differs from one to the other. But in essence, you're going to need to be prepared before any breach. to comply with these red flag regulations, to know who you are going to use to assist if there is a breach. And that involves a forensic investigation, retaining the outside help of a PR firm, outside counsel. All should be done in advance. It's too late once it happens to determine what forensic analyst you're going to retain, or what law firm, or what PR firm. You should, and I believe is required by the red flag rules, to do that in advance. That's part of your prevention and your mitigation responsibility. Updating the program on an ongoing basis, probably yearly. I would also say that testing the program would be expected. When new account offerings are presented, you have to go back and see if these account offerings raise the possibility of different means of identity theft. And of course, vendors. When you're contracting with vendors with respect to your different services or service providers, financial institutions under the red flag reg are responsible for their service providers notifying you of red flags that they have seen in their work that you have listed in your program, and informing you, identifying those. That's going to be, and we've experienced a difficult situation in contracting with vendors. We don't know how that'll end up, but essentially you have to work as diligently as you can to be sure that your providers are able to notify you of those things that you've identified are indicators of identity theft. Oversight, board responsibility, monitoring, and all that. Let me mention, there's some good guidance and information in the FINRA website on compromised accounts. It's helpful. Customer information protection, and those sites are very good. I'll also mention the broker protocol that you may be familiar with, the voluntary program that brokers, dealers have signed on to. It deals with the movement of information when reps leave from one company to the other, from one firm to the other, how that information is used, how customers are notified, what is required in that agreement to be what I would call safe and sound. I commend those to your attention as well. Talk about the cyber insurance market. I think that as we go forward, regulators are going to look at what financial institutions may have done in exploring obtaining cyber insurance that would cover losses in this area. Our general liability policies have now been pretty much eliminated as a source of coverage, but the markets have responded in the cyber insurance in many ways. The cost and the average pricing has gone down, and I will just mention that expenses, liability coverage, media liability coverage, these policies can cover just about anything, and they're worth looking into. And the best practices. I think the most important thing that you can do is to have cross-department communication, input, responsibility, buy-in, right and left, top to bottom. Given these regulations, it's going to be extremely difficult to focus in one part of a financial institution to have an effective program. That also, it requires top-level management buy-in, influence, both with regard to breach response and cyber risk management. And that ties into budget analysis. The focus used to be the budget of the IT department is where we're going to focus, but you have to look beyond that. And of course, legal expenses might be part of that as well. But certainly operations, training is a key component, and being updated from time to time on new developments is critical. Thank you very much.